You absolutely have to listen to today's case all the way through. The parents almost paid for the house in full and lived in it themselves, but when it came time to sell, the son-in-law jumped in and said he wanted half. Can you guess where the problem is? A while back, I had a client whose parents paid for a detached house in Markham, and the title was put under their only daughter's name. The reason was simple. The parents didn't have Canadian status. They were living in Canada long-term on a super visa. It was the parents who were living in the house, and they were also the ones mainly paying the mortgage. The daughter was already married and living with her husband and his parents. So essentially, this house had almost nothing to do with the son-in-law. But in Canada, the capital gains from a principal residence are usually exempt from capital gains tax. So the daughter made a smart decision. She declared this house as the principal residence for her and her husband. And that's where the problem started. In Ontario, as long as a home is the principal residence during the marriage, it can be considered a matrimonial home. The legal status of a matrimonial home is quite unique. It doesn't matter who paid for it, who lives in it, or whose name is on the title. Once it's recognized as a matrimonial home, if there's no prenuptial agreement explicitly excluding the portion contributed before marriage, then the net value must be split 50-50 in the event of a divorce. Also, both parties must sign off when selling the house. A few years later, the parents decided to sell the house and move to a smaller one. When the sale documents were handed to the son-in-law for his signature, he immediately jumped in and said, "This is our matrimonial home. I want my rightful share. This isn't just theoretical." He actually asserted his claim. Someone who didn't put in a single cent is now legally claiming his rights. The parents and their daughter never imagined things would come to this. The family dynamic completely fell apart on the spot. So why do so many people fall into this trap? A lot of Chinese families have this deeply rooted belief: whoever's name is on the property title, that's who owns the house. Back in China, that's often how people see it too. But in Ontario, the legal status of a matrimonial home outweighs whose name is on the title. To save a bit on taxes, people declare the house as the primary residence during the marriage, which basically means they're voluntarily putting it under the rules for matrimonial homes. If something goes wrong in the marriage, it's not just about saving on taxes. You're basically gambling with half the net value of the entire house. So a lot of people ask, in this situation, should you treat it as a rental property instead? To be more precise, if the daughter never actually lived there, and her husband's primary residence is somewhere else, then this house typically wouldn't naturally be considered the couple's matrimonial home, nor would it necessarily meet the criteria for primary residence for tax purposes. But once you declare it as the couple's primary residence just to avoid taxes, you're actively exposing yourself to risks under family law. Tax law and family law are actually two completely different systems, so don't trigger the matrimonial home rules just to save on taxes. As for the specific structure, the most reasonable arrangement must be jointly planned by a professional accountant and a family lawyer. For more topics on the division of matrimonial homes, parental contributions, and prenuptial agreements, feel free to check out my previous videos. I'm Priscilla, specializing in first-time buyers, sellers, and upgraders in the GTA.